Hello students, today we will introduce ourselves to a new branch of law called the private international law. It is also known as conflict of laws in many other jurisdictions across Europe. Private international law is a branch of law arising from the diverse laws of various nations. It applies when private citizens of different countries interact or transact business with one another. It is administered between private citizens of different countries or is concerned with the regulation, the definition and the enforcement of rights in contracts and relationships based upon party autonomy, that is, the free choice by the parties. In this respect, private international law differs from public international law, which is the set of rules entered into by the governments of various countries that determine the rights and regulate the intercourse of independent nations. The foundational aspect of private international law is traced to the fact that courts in one country are often called upon to notice a different rule of law on the same aspect in another country. Two reasons necessitate the recognition of foreign law in a case containing a foreign element. They are: number one, the application of the local law by the court would lead to a gross injustice. Number two, the necessity of taking notice of foreign law to make a rational judicial decision. Now, this lecture discusses the definitional aspects and the scope of the subject. It further attempts to trace the development of the subject through the historical and the theoretical traditions that impacted the crystallization of this branch of knowledge. It also highlights the ever increasing expanse of this knowledge domain's application. Now, the objectives of this lecture are a few. They are to understand the positioning of this subject in the global environment, to appreciate the utility of learning this branch of knowledge, and to understand the development of this subject and its practice in various jurisdictions. Frederick Harrison explains the scope of the subject as relating to any action, either in common law or in civil law systems, or in an equity-based action, or in a divorce case, or a bankruptcy case, in a shipping case. The most trivial action of debt, the most complex case of equitable claims, may be suddenly interrupted by the appearance of a knot, to be united only by private international law. They would have a feature of a foreign element in it. Such foreign element could be related either to the parties, to the choice of law governing the rights under the contractual relationship between the parties, or even to the territory where the cause of action for that particular civil law related claim has arisen. Now, sometimes parties might wish for more than one legal system to govern the various rights arising from such contractual relationship, necessitating the application of more than one foreign law. Most common law countries, including India, consider the following definitional aspects as the subject matter of private international law. They are: rules relating to jurisdiction of courts, rules of choice of law, and finally, the rules relating to recognition and enforcement of foreign judgments, decrees, awards. Now, why do we need to apply the foreign law at all? Aren't all matters before the local courts to be decided applying the law of the land? Aren't all sovereign states entitled to control and application of their own law to disputes arising on our territory? Now, the space for application of foreign law has been derived from a few traditions. They are: the application of foreign law by the local or the forum courts is founded upon the principle of comity of nations. Many modern thinkers, however, opine that it is an incomplete explanation for modern, complex transnational relations. The necessity for application of foreign law for the determination of the rights of the contracting parties is a more cogent explanation emanating from recent times. Foreign law needs to be applied in the interests of justice, as application of the lex fori or the forum law may not be the ideal handout of justice in suits involving foreign element. For example, application of English law, which happens to be the lex fori, since application has been made before English courts to a divorce application for a marriage that was validly performed outside England, but invalid according to English law, would be a travesty of justice, as parties would then not have any rights arising out of the marriage. It is also a matter of convenience to apply the foreign law, as parties themselves have chosen to be governed by such law. One of the most important aspects of private international law has been the activity of unification in the subject, with many countries adopting different standards and methods for applying foreign law and for recognition of foreign judgments. The diversity in the law created difficulties, with rights of the contracting parties being interpreted differently in various jurisdictions. Prior to unification in 1951, much of the effort was in the geographical region of the European continent. Brussels Convention on the Unification of the Rules regarding Carriage by Sea, Warsaw Convention on the Rules regarding Carriage of Persons and Goods by Air in 1922, unification of internal laws in countries like Finland, Denmark, Norway and Sweden in areas like bankruptcy laws and res judicata. Unification attempts were seen in the civil law system countries of the Soviet Union and the people's democracies of Eastern Europe. Established through a charter in 1951, the Permanent Bureau of the Hague Conference has seen much success in the areas of family law relating to divorce, legal separation, adoption, guardianship, protection of minors, international validity of marriages, and conventions on the recognition and enforcement of foreign judgments in civil and commercial matters, protection of the legal personality of the foreign corporations, to regulate conflicts between law of nationality and the law of domicile. UNIDROIT is one of the most important attempts in contemporary times. The International Institute for the Unification of Private Law, also known as UNIDROIT, is an independent intergovernmental organization to study the needs and methods for modernizing, harmonizing and coordinating private and in particular commercial law as between states and groups of states, and to formulate uniform law instruments, principles and rules to achieve those objectives. Its work includes principles for transnational civil procedure, principles on commercial contracts in 2010, UNIDRAW Convention on substantive rules for intermediate securities, unification through regional and bilateral conventions and treaties. Scandinavian countries were especially successful in unifying the rules of private international law relating to marriage, adoption and guardianship amongst these countries, despite different standards for deciding matters of personal law. For example, Norway and Denmark follow the law of domicile. Sweden and Finland laws follow the principle of nationality. They resolved this through the principle of the party autonomy. Benelux countries made similar attempts in personal law matters such as status, capacity, divorce, successions and essential validity of contracts. The development of private international law is an interesting aspect of research. Some of the doctrinal explanations for this separate branch of study are the statute theory, the international theory, the territoriality theory and the theory of acquired rights, the local law theory and the theory of justice. Now, the statute theory was propounded by an Italian scholar by name Bartolus in the 13th century to address the conflicts between the laws of the various city-states and also the conflict between the laws of the city-states and the Italian law through statutes. Now, these statutes are largely composed of restatement of customary laws related to the commercial community. Now, three types of statutes were identified. The first, statuta personalia, which is based upon the principle of domicile. The statuta realia, which is also based upon territoriality. And third one, which is the mixed statutes, for all actions done in the country where the law was made and enforced, even if such action was filed in a court of another jurisdiction. Thus, a person domiciled in Milan would continue to be governed by the law of Milan even when he went to Pisa. Now, while it comes across as a great value theoretically, the essential difficulty about it comes in classifying what actions would come in either of these categories. The next theoretical tradition is the international theory. Friedrich Carl von Savigny, in his work System of Modern Law, opined that the statute theory faltered in classifying the laws on the basis of their object. It should actually be classified on the basis of the legal relationship. Every legal relationship has its root in some local law, and therefore, the work of the jurist is to find out that natural seat. He developed rules to enable one to trace the legal relationship. The seat of the thing is the place of its location, and the seat of a legal relationship of the capacity of the person is the place of his domicile. Cheshire opined, in the light of all relevant circumstances, they attempt to decide each case according to the legal system to which it seems most naturally to belong. Now, the third tradition is called as the territorial theory. Dutch jurists picked up the real statutes and theorized it into the territorial theory. They say that courts apply foreign law only to the extent permitted by their own sovereign law, thus giving reason to the Committee of Nations. The theory also gained support in England. Dicey puts it in the following words: English judges never in the strictness enforce the law of any country, but their own, and when they are popularly said to enforce foreign law, what they enforce is not a foreign law, but a right acquired under the law of a foreign country. Now, the next theoretical tradition is called as the local law theory. American jurist Walter Wheeler Cook reasoned a realistic understanding that no court ever enforces foreign rights as such. It discusses these foreign rights with the scope of the local private international law rules, which direct it to another country's substantive law. An American court, when asked to order damages for an alleged foreign tort, would apply the substantive law of the other country in question, while saying that the foreign law governs in such actions. An American court is not handing over the case to any foreign law. When courts of the forum decide cases involving foreign element, they apply their own law, though in doing so they adopt or enforce a principle similar in scope with a rule of decision found in the law of another country. Such rule incorporated into the law of the forum may, for convenience, be called the domestic rule of the foreign state. The forum thus enforces not a foreign right, but a right created by its own law. The next theoretical explanation is called as the theory of justice. This is a theory stated as being pragmatic. Its premises drawn from English law and judicial opinion. Graveson opined that there is a threefold value of this theory. He calls it as sociological, ethical, and legal. Sociologically, it presents the idea of a fair treatment in the private transactions of individuals. Ethically, it reflects the traditions and training of English lawyers, judges, and legislatures as proponents of justice. Legally, its mainstay is the language of the judge's oath. This theory cannot be stated as a perfect solution applicable for all situations. Nevertheless, it emphasizes the necessity of grounding the principles of private international law on the benchmark of justice. Now, why is it that we need to study these theoretical constructs at all? The utility of these theoretical constructs lies in the fact that all the theories believe that courts of the forum have to apply foreign law. Economic needs and questions on the shrinking space of sovereignty today are the major reasons for the ever expanding significance of this subject. Now, let's chart the development of this subject. Now, the documented English history in the area of private international law is nearly 4 centuries old. The history of this area of study has had a much older grounding on the continent though. As such, we begin tracing the historical antecedents from the continent. Now, the era of the territorial law says that in recorded history, the Roman Empire provided a picture-perfect setting for the development of the rules of private international law. With a clear identification of the laws applicable to the Romans and the citizens of the provinces, questions of conflict between the laws in interactions between Romans and citizens of the provinces remained unexplored. The only exception to the above situation was that concepts like domicile, lexitus governing disputes regarding immovable property found their place in the Roman law. Now, the next stage in the development is the era of personal laws. Personal laws meant that wherever a person went, he carried his law with him. Two exceptions were recognized, though, that criminal law would be common, and secondly, the canonical law that is applied to all is also common. The state of development was so high that there were occasions when the individual could specify the law governing his actions, which was of tremendous value in a country like Italy, which had a huge mixed population. The era of feudalism and city states. Personal laws were substituted by feudalism in the north of the Alps and also in the city states in the south, where no foreign law could be applied. The south of Alps also saw territorial law preference. All persons living in the city state ought to be governed uniformly by the law of the city states. However, the city states saw progressive increase in the trade and commerce relations, moving towards acknowledgement of the space of private international law. The era of the statutus. Increased trade and commerce by the 13th century made the city states acknowledge and implement the need to recognize each other's laws through statutes. Now, the difficulty of this theory is, however, that allocation of any action to its specific statute. Dutch jurists, for example, attempted to answer this question by calling such conflicts involving the foreign elements as the sovereign's prerogative. Now, the modern era has been traced by Savigny. He says that the object of this branch of study is to establish a connect between the legal relationship and some territorial law. Events of conflicts between territorial law and the law to where dispute belongs could be decided by applying the law of the place where the matter belongs to. This led to the principle that personal matters shall be decided upon the principle of nationality. Now, the English private international law. The history of private international law in England in the 17th century. One of the earliest examples of the English courts taking notice of the foreign element was in the Wares case, where the court recognized foreign judgment. Surprisingly, English courts were willing to enforce foreign judgments despite being reluctant to entertain foreign suits. Lord Mansfield in Holman versus Johnson, demonstrating a shift towards recognition of foreign law, opined, "Every action here must be tried by the law of England, but law of England says that in a variety of circumstances with regard to contracts legally made abroad, the law of the country where the cause of action arose shall govern." Now, the evolution of Indian private international law. Post independence, the situation has been aptly summed up by the apex court. The net result is that the courts in India are now at liberty to lay down and follow their own rules with regard to private international law. And in this regard, we are in a very fortunate position, since we can adopt the rules laid down in various countries as accord best with our sense of justice, equity and good conscience, and avoid their errors. Now, some of the contemporary areas of interest within this domain include its ever increasing presence in a scenario where national borders are being confined to very little relevance, and people and commerce in real and virtual space has seen increasing migration. With ever increasing diaspora and the interaction with different legal systems, private international law today has its role in family law disputes like custody, maintenance, divorce and its related decrees, orders, judgments handed out in a foreign court and sought to be enforced locally. Increasing incidence and regulation of cross-border surrogacy arrangements, transnational commercial contracts, their performance and enforcement, internet-related disputes, intellectual property-related disputes, foreign dispute resolution mechanisms like the arbitral tribunals, international commercial courts at Dubai and Singapore, and more coming up. Increased interaction between private citizens across borders in more ways would mean an increased role and utility for this domain knowledge. Now, to conclude, we have now understood the space of operation of this branch of law. It provides the ways to resolve the conflicts within the legal provisions that arise in transnational, family and commercial relationship disputes. Thank you.